judge in the Daniel Penny trial giving an unprecedented lifeline to Alvin Bragg and the prosecution. He's dismissing the most serious charge of manslaughter in the second degree after the jury was deadlocked on it all day. But Penny still faces a second lesser charge for negligent homicide. Let's go right to CB Cotton, who is live outside the courthouse in New York City. CB.
Hi, Jesse. Well, Daniel Penny's fate still hangs in limbo now that jurors return on Monday to debate whether he's guilty of that lesser charge, criminally negligent homicide. As you mentioned, the judge dismissed the most serious charge in the case, second-degree manslaughter, after jurors came back twice saying they were deadlocked on it. Around noon today was the first time that they announced they couldn't reach a unanimous decision, and the judge had to give what's called an Allen charge, which is when a judge urges jurors to go back, deliberate, try to reach a verdict. The judge overseeing the trial explained to jurors, hey, if you don't reach a unanimous decision on this charge, a new trial will be set with a new jury. But around 3 p.m., after the lunch hour, they came back deadlocked again. There was debate between prosecutors, defense attorneys, and the judge ultimately making the decision to dismiss that top charge. Since when deliberations first began on Tuesday, jurors have asked to review several pieces of video evidence in the case, parts of the medical examiner testimony, and they've asked the judge to review parts of the law. Retired New York City criminal court judge George Grasso explained to me what makes this case so hard for jurors.
Well, that's the reason why this is such a hard case for jurors acting in good faith based on the evidence presented in front of them. They start off with the premise that the defendant in this case was a good man trying to do the right thing and act as a good Samaritan and help people. And now they're being asked to potentially convict this man for manslaughter and/or criminally negligent homicide. That's a hard burden that they have.
And Penny still faces a potential prison sentence of up to 4 years in prison if jurors find him guilty on this lesser charge. Jesse.
All right, CB, thanks very much. Harold Ford Jr., you happen to be the only lawyer at the table. Am I right? Is there any other lawyers?
I am a JD from Harvard, so.
Oh, wow.
But I don't practice, okay?
Wow.
Yes, you practice.
I defer to Kayla. I'm just a Michigan guy. Go blue. Beat Ohio State this
Big win. All right, we're going to go Ivies over Big Ten. Fine, let's go.
Okay, so here's what I think. I know a lot of people are saying, look, this first charge dismissed, right, the 15 years. This makes it easier for the second charge to go through. Here's why I disagree. 12:30 p.m. on Outnumbered, we had a jury note that came in. And the jury note said that the jury wanted clarification on what a reasonable person standard is. This is why it's important. This goes to the negligence charge, that one carrying 4 years. And they ask you, would a reasonable average person have perceived the risk to Jordan Neely? Well, there seems to be disagreement if they need clarification on the reasonable person. I'm hopeful there. But when you look at this, the reasonable person, there were many reasonable people on that subway train. The bystanders who thanked him, the bystanders who helped him hold down Jordan Neely, the woman of color who said this, they're trying to make this about race. Well, a woman of color, that's how she self-describes, said he is a hero. It was self-defense. He is only guilty of trying to help people. Those are the reasonable people on the subway. This is a travesty. It's great news. The first charge is gone, but not a victory, a travesty. A good Samaritan being made into a bad actor, a hero into a villain. Welcome to Manhattan. The only other jurisdictions that could do this were D.C. and L.A., so good job, Alvin Bragg.
Do you agree with Kaylee as a Michigan graduate?
The characterization of Michigan being less than an Ivy League, I'm not going to accept.
Oh, okay.
I will say this.
You're a swing state.
I largely agree with Kaylee. I come at it slightly different. I think that what the judge has done here is that there might be grounds for reversal if he's convicted of anything, because you can't go through a trial and then allow the prosecution to say, we believe that one of the charges, because the jury can't come to a conclusion, should be dismissed. I think the judge, I'm going to be curious to see once we get more information about how the judge came to this decision. Two, what I don't quite understand, I've followed this case. I'm obviously not on a jury and have not received all of the evidence and don't have all of the things that they've seen. But if indeed Kaylee's right, a reasonable person if he grabbed that guy, because the guy was threatening everybody, and he doesn't let up, or say he did let up, and the guy pretended that he was down or was suffering, and he lets up, and the guy stabs him, stabs Daniel Penny.
That's exactly right.
So Daniel Penny, I don't know. I think it was unfair to even who had brought these charges. You make the case basically to anyone in New York, and for that matter, this is a precedent that can be cited anywhere, that someone trying to protect someone on a train. I have kids, right? I have a 10-year-old and 9. We live in New York City. My wife and I, we live in New York City. I take the train. And if my wife and kids are on a train and someone is behaving like that, and someone steps up to protect those on the train, I'd be damned. As a New York taxpayer, I'd want to see that person prosecuted based on these facts. So Michigan versus Harvard, I'd say it's a tie.
I agree.
As we get here at 5 o'clock.
And the mayor is getting involved. Katie, let's listen to what Adams has to say.
We've always asked New Yorkers, you see something, say something, do something. And New Yorkers have always had the spirit and energy to come to their fellow New Yorkers. And we have to be honest about the severe mental health crisis that we're facing. And this young man was part of that problem. He was in a revolving door mental health system.
Katie.
Well, I'm glad that the mayor is defending Daniel Penny. This is a case that should have never been brought. In fact, it's a case that sat at the police department for nearly 2 weeks. But then when the social justice woke mob showed up to protest, that's when Alvin Bragg decided to give in to mob justice, and bring these bogus charges against Daniel Penny, who is a hero who's had to go through this for the last year of his life. It's totally changes everything when it comes to the consequences of this. Now nobody wants to help on the subway because is it really worth being made an example of in Manhattan and New York City to have your life torn apart this way? You know, Alvin Bragg has a habit of either undercharging or not charging criminals like Jordan Neely, who was in and out of the system, had a long rap sheet, while overcharging good Samaritans and good people who want to help their fellow citizens like Daniel Penny. And so now you have this judge pushing this till Monday when the first charge was dropped at 4 p.m. on a Friday. Used to be that you would work until you were done. So now this has to sit for the weekend. They're trying to squeeze out a guilty charge on the second charge, basically saying, well, they didn't get him on the first one, so now maybe they can get him on the second one. And the consequences of this for the entire country are so far-reaching in terms of what this man has been through. And the people who will suffer the most, of course, Daniel Penny is one of them, but it's the people on the train who will be at risk to these criminals who will now be able to say, well, I'm not the one who's going to be charged. In fact, people can go as a mob to the police station and to Alvin Bragg's office and demand that good people are charged when it's clearly, obviously, self-defense, should have never happened. And they're not going to do anything, which means there'll be more innocent victims as a result of just bringing this case in the first place.
Joey Jones.
Yeah, I think this is a case where and this is not an original idea. I was talking to a friend just before the show, and he brought it up. Of like, you're looking at the intent of the law versus the letter of the law. If you ask those same 12 jurors with the amount of evidence they've been shown today, and you present it to them and you said, should we indict him? You could probably get a unanimous no. But now that you've given them the facts and you've given them this second charge that is, I guess, ambiguous to say the least, there may be several people there that say this guy did the right thing, but by this law and these facts, we're going to have to convict him. And that's the real travesty here, is that you have a charge written in such a way that you can justify it with less facts than you should have to have more behind you there. I think some of the things that really hurt him is just about every witness that came up that said something the defense could use also said something the prosecution could use. Like the Marine combat instructor, ultimately the question was asked, did he do it correctly? And I think he said no, or he said something along the lines of he should have let up, at some point. And so there may be this narrow path there to where this jury feels compelled to convict on this second charge simply because they're being asked to, as opposed to are they being asked, is it right to put him in this situation to begin with? That's how I see it. Listen, this is not a regular citizen. This is a United States Marine that our federal government paid and programmed to stand up and do the right thing even at his own detriment. On the battlefield, he gets a Bronze Star for that. In New York City, he gets what? 15 to 4 years in prison.
Yeah, great point.
And so that it pisses me off, but it also blows my mind. Where I live in Georgia, I probably could have been justified at pulling a firearm on that guy if I felt like he was coming at me at any moment. We weren't there, so we don't know if he ever made this motion. We don't know if there was ever a specific point. But if there was any point like that, in my state, I'm justified to use a firearm to protect myself. And in this city, using the least lethal method, they're going to throw you in jail? I mean, it's horse crap is what it is.
And what the court has done is terrible. I mean, I really do think this is grounds for reversal, what this judge has done. You can't just throw everything at the spaghetti on the wall, and then when when the jury is deliberating, it's not going your way. So we'll pull that one down so the others. So again, I hope that the right thing happens here, but if it doesn't, this is certainly grounds for reversal, if not.
Good evening, Aisha. Daniel Penny's fate is still in the hands of jurors through at least Monday when they return here to the courthouse to deliberate whether the Marine veteran is guilty on the lesser charge, criminally negligent homicide. So the jury sent one note this morning saying they could not reach a unanimous decision on whether Penny was guilty on the most serious charge, second-degree manslaughter. The judge then read an Allen charge, encouraging them to deliberate again and reach a verdict. But by the afternoon, jurors returned still deadlocked. Penny's attorneys argued the deadlocked jury was grounds for a mistrial. Prosecutors asked for the manslaughter charge to be dismissed so jurors could deliberate on that lesser charge. The judge granting prosecutors' request, but defense attorneys said multiple times in court they felt the move was coercive. Tonight, Penny's defense team tells Fox it's trying to remain level-headed for Monday and says, quote, "We are cautiously optimistic that the one remaining count will be dismissed by the jury on Monday. That would finally put the nightmare behind Danny and allow us to focus on the civil lawsuit filed 2 days ago for the same allegations contained in the criminal indictment." Penny's defense argues their client protected others from Neely, who was making threats on the subway last year. Prosecutors argue Neely's outburst only lasted 30 seconds and Penny went, quote, way too far. The Neely family says this case is about racism.
Racism is still alive and kicking in America. There's no other way to view this. Everyone has looked at the case, and those among you who say that Daniel Penny is innocent have racism and bias in your heart.
On the lesser charge, Penny still faces a penalty of up to 4 years in prison, but under certain circumstances, the judge may choose to impose a sentence of 1 year or less. Lots more to watch. Aisha.
CB Cotton live for us in New York tonight. CB, thank you.
Well, it still is not clarifying, Martha, because it matters why the jury can't reach a verdict. Basically, what their instructions are is if they accept Penny's justification defense, that's the end of the case. So in other words, if what they found is that Bragg could not prove beyond a reasonable doubt that the justification defense was negated, then that's it. The case is over. If they rejected the justification defense, but they can't resolve the case for some other reason, then that would be a reason to move on to count two. Because, for example, if they couldn't find recklessness beyond a reasonable doubt, that doesn't discount the possibility that they could find negligence, which is the second count. So I think we're going to have a lot more struggle back and forth between the two sides, because they were hoping for a clarifying verdict on count one in order to know whether the case was over or whether they could move on to the second count.
Exactly. So the prosecution, the burden on the prosecution is to prove that Daniel Penny was not justified in taking the action that he took on that subway. But if the jury finds that they can't agree, they can't come to a unanimous verdict on whether or not Penny was justified to spring into action and to put him in a chokehold, that would make the whole thing fall apart, correct? So give us an example or a scenario, and and add whatever you're about to say. But I just want to get this in, where it would become necessary to keep that second negligence count relevant in terms of their deliberations, Andy.
If they rejected the justification, Martha, but they found that he wasn't reckless. Now, recklessness is a very high standard. It requires finding that he perceived a risk of death and then wantonly took actions that totally disregarded it. Whereas negligence means you didn't perceive a risk of death, but you acted in a way that a reasonable person might not have under the circumstances. So they're very different conclusions. If that's what it is, then the lack of recklessness doesn't discount the possibility of negligence. Whereas if he had justification, then he had it for both counts and the case has to be over. The one thing I was going to add is the thing I'm concerned about is that the prosecution, Bragg's New York DA's office, Manhattan DA's office, what they may try to do is get the judge to dismiss the recklessness count, the manslaughter count, count one, and on that basis have the jury go in and resolve count two. I think that would be terribly unfair given the way the case was tried, but that is something they may try to do.
Well, you always said, Andy, that you felt that the reason that Bragg brought that second charge of negligence was so that this jury would have something to fall back on in his intent to make sure that there was something that they could find Daniel Penny guilty of, right?
That's exactly right. And I think, unfortunately, the strategy is working the way it's designed to work. So, you know, you have some jurors who are obviously ready to find him guilty of recklessness, which I find mind-boggling because I don't see how that's supported by the evidence in this case. But that's designed to make the other jurors feel like, well, maybe if we convict him on negligence, but we acquit him on recklessness, we're at least being fair and we're trying to, you know, reach a middle ground with our, you know, opposing jurors. That's what I think Bragg has tried to set up, and it may be working.
This is really good news, bad news for Daniel Penny, what this judge did. If you think about it, you've got some jurors. We don't know how many, Laura. It could just be one juror that was hung up. There might have been 11 jurors wanting to acquit Daniel Penny on the manslaughter charge, and maybe just one juror that wanted to convict him. But the fact that there was a hung jury on the more serious charge is not great news for Daniel Penny, because now the judge is saying on Monday they want the jury to hear the lesser charge, right? The negligent homicide's just being reckless, and that caused the death. If you've already got one or more jurors that are hung wanting to convict Penny on the more serious charge, then rest assured, when they deliberate on Monday, they're going to want to convict him on the reckless negligent homicide. So that's the bad news for Daniel Penny. The best he's likely to do is a hung jury. The good news is he's got some jurors in his camp that hung on the more serious charge. Those jurors are likely to stick with him on Monday. So we're likely to see a hung jury by Monday or Tuesday on a lesser charge.
Now, Jordan Neely's uncle spoke today at the end of the deliberations. Watch.
On behalf of the Neely family, I want to apologize to all the people that was truly afraid for their lives on that train. Jordan Neely didn't have to die that day. Daniel Penny could have went to another cop. Even he has the legal right to do so.
Andrew, I mean, that's emotional, but frankly, it's absurd.
It's absolutely absurd. Look, there's something in the law called the assumption of risk. And when you act like an idiot, when you act like an imbecile, when you intimidate people, when you threaten people, you assume the risk that something is going to happen. Laura, this criminal justice system has completely failed this Marine. From Alvin Bragg bringing these charges in the first place, the lead prosecutor not agreeing to a plea deal with a slap on the wrist, and now this judge who shouldn't have dismissed these manslaughter charges. Rather, there should have been a mistrial in this case. And let's start this entire thing over again, because now I'm concerned that you know, the defendant in this case is going to be convicted on Monday, and that's a miscarriage of justice. It's ridiculous.
I completely agree with you because, and again, let's remind the viewers what we're talking about here. So they dismissed the more serious charge. But now the lesser charge is criminally negligent homicide. Now, what does this involve? It involves causing someone's death by acting in a manner that was reckless, inattentive, or careless. In addition, if you've recklessly failed to act and as a result someone dies, you could also be found to have committed criminally negligent homicide. Brian, there almost seems to be a feeling you would intuit among some jurors that, okay, maybe we'll go with that one. That's not Laura, how the justice system is supposed to work here.
Yeah, absolutely, Laura. And that's what I meant earlier. It's like you've got some jurors that are saying, hey, look, They believe Penny consciously was in disregard of Neely's life, knew the risk, still did the chokehold, and therefore he should be found guilty of manslaughter. Do you think those jurors now are going to do a 360? No, like you said, they're going to be like, okay, well, I'm going to get him on the lesser charge. But let me tell you one thing, Laura, where this judge messed up and where there's going to be there should have been a mistrial on this entire case, and Penny's lawyers are going to have a great appeal issue. The judge should have asked that jury why they hung, because there's a legal justification defense for Penny. That's a self-defense. And if this jury agreed that Penny was entitled to self-defense, then he's off on both charges. If that jury hung on the justification issue, then the entire case should have been dismissed. That judge never asked. And that's an appealable, erroneous issue on the judge's part.
Well, it's clear that there's dissension amongst the ranks, and there is a fallback position of going to look at the criminal negligence charge. And really, when they started to ask the notes about the reasonable person standard, that focus really started to circle on that lesser charge that we've been talking about being a fallback position for this jury to consider. And that really is the bottom line for that jury is to decide is whether the actions by Daniel Penny were reasonable, justified, and he did not know of the inherent risk of putting Jordan Neely in that chokehold that ultimately led to, at least the prosecution side is trying to show that it led to his death. So that focus as to what a reasonable person would have done under the same circumstances that Daniel Penny found himself in at that time in that subway car was reasonable. And this whole thing about foreseeability, what he should have known, what he should have done is really going to focus on that training. We heard a lot of what the prosecution tried to establish over and over again, that this isn't an ordinary citizen. Daniel Penny was someone that had martial arts training. They brought in the martial arts expert. They really tried to glorify this Daniel Penny as an expert in chokeholding and that he had done something and did it recklessly, which then ultimately led to Jordan Neely's death. But that focus is going to be very much as what that reasonable person would have done under those same circumstances.
All right. So as I understand it, what we're just getting is that there is a discussion over whether or not to dismiss count one on the part of on Bragg's part on the prosecution side and allow them to continue to deliberate over count two, this count of negligence. Your reaction to that, Mercedes?
Well, Martha, you've already heard the defense attorneys have been asking for a mistrial. They said this has been 4 days of deliberation. This is not a complex case. This should be declared a mistrial and move on. You'll hear I'm sure the defense attorneys will again ask for a mistrial. They will oppose their consideration for the fallback position on the criminal negligence side, on the charges on the criminal negligence part. They're going to be adamant that this should result in a mistrial and not another consideration. This is one of the things. So we'll have to see. There's a few decisions this judge has to make. Should they allow that consideration of that lesser charge? Should an Allen charge be also made with respect to the lesser charge? And whether or not the judge is going to dismiss that first count, all of which are problematic. Anytime you have a criminal proceeding where an Allen charge is being set forth by either the prosecution asks and the judge acquiesces and gives that charge, it is particularly dangerous. And we heard those arguments by the defense attorneys. The defense team made it very clear in the courtroom that when you make this type of charge, you are bullying the jury. They've already told you that they cannot come to a decision. Now, if the judge decides for a second Allen charge to be done with respect to the lesser included charge, it will be problematic. I'm sure it may result in the conviction of that lesser charge. And ultimately that will be the fodder for appeal if it goes into that route and he is in fact convicted.
Yeah, we're looking at the video right now of the Manhattan's DA's office of Daniel Penny. As he was standing there with police officers, he waited for the police to come. He tried to thwart this threat for the passengers on that train that day. We have video from those individuals saying that they were grateful that he went into action to try to prevent this threat for them on the train. And you can see he cooperated throughout, Mercedes, speaking with the police, then going in without an attorney to speak to the investigators, and telling them, as we all watched on the video, that, he didn't intend to injure him. He was trying to protect the other people on the train. It's a stunning situation. With regard to the Allen charge, so it's redefining essentially the instructions that the judge gives to the jury. It's like, okay, now you guys can't reach a conclusion on this. Let me see if I can help define it further for you so that you can reach a conclusion. But is that in and of itself in this case, Mercedes, going over the line for this judge, in your opinion?
Well, it could be. I mean, that's certainly what the defense is going to argue, that there's activism taking place, that there is this need, at least there's this compunction that Daniel Penny has to be convicted of something. But the more activism that you see a judge exert and going through and redefining those jury instructions are so critical, and they are the basis of most appeals when there are convictions. So we have to, judges have to be very, very careful when they start to redefine those jury instructions. So if there is activism, it'll be continued fodder for the defense if they have to indeed seek an appeal if there's a conviction. But it is very dangerous waters that this judge is wading in, and frankly, really should show some restraint and allow for the process to proceed.
Click here to subscribe to the Fox News YouTube page to catch our hottest interviews and most compelling analysis. You won't get it anywhere else.